Mr. Smith, I'm conscious that you lost an appreciable amount of time this morning. What I'm minded to do is extend your time in opening by 20 minutes. So give you another 20 minutes to make up for the adjournment. And we can see what progress we make later in the week. But if need be, we can then sit early on Friday morning. If we sat at 10, we could have a 10-minute break mid-morning, but fit in the additional 20 minutes that way so that Mr. Gillis doesn't lose out either. I'm
very grateful for that. Thank you. So just continuing on with contributory negligence, just on this first aspect, which is the point of principle, just two final points to make. The first is to deal with the concepts of same-day construction and updating construction, to use the terminology of the respondents. Same-day construction is obviously self-explanatory. It's just a question of looking at the statute, construing it as it stood when it was enacted. Updating construction is seeking to promote the idea that a statute is always speaking, to use the language I think your lordships used in the FIA case, amongst others. In our submission, there's three fundamental problems with the updating construction argument in this case. The first is it ignores the purpose of the statute and the mischief which it was designed to address. In our submission, as I've already explained, the purpose of the statute was to remove contributory negligence as a defence to claims where it would otherwise have defeated the action, and to substitute the right of apportionment. Now, if that's the purpose, all you need to know in order to know whether the Act applies is whether, apart from the Act, contributory negligence would have been a defence at common law. That is the only piece of information you need to ask yourself and answer in order to work out whether the Act has any application. Now, if we're right about that being the purpose, the concept of always speaking, updating construction doesn't have any application. You simply, when faced with a claim, ask yourself, well, but for the Act, would the defence of contributory negligence have applied? Now, secondly, the point actually goes somewhat further than this, because in our submission, updating construction is sought to be used in this case to extend the Act well beyond its intended purpose. Now, assume we're right that the contributory negligence wasn't a defence to a contractual claim at common law, including when there was concurrent liability in tort. The respondents say, well, nonetheless, you should be able to apportion in reliance on the statutory power. Now, that is obviously going well beyond what the Act originally contemplated, because what they are saying is that you should be able to apply the right to apportion, even where you have a cause of action which wouldn't have been the subject of a defence of contributory negligence at common law. And effectively what they're arguing for is a freestanding right of apportion. Now, one can understand why one can lapse into that way of thinking, because people do look at Section 8.1 and think it's all about apportionment. But actually, that's not what it's all about. It's actually about removing the defence. And the quid pro quo for the removal of the defence is the apportionment. The apportionment isn't a freestanding right or remedy or power. It's, as I submitted in opening, it's ancillary to what the section is doing in the opening words, which is removing the defence. Now, the third problem with updating construction also is it simply assumes what it seeks to prove. I mean, it assumes that the right of apportionment should apply to contractual claims where there's also liability in tort. And that's one view as a matter of policy, but there's a contrary view that it should not, and that where you have a contractual liability, why should that be reduced merely because there's also a concurrent liability in tort? So it doesn't grapple with the fact that in any event, it's a question of policy on which there are competing points of view, competing interests. So that's what we'd say about updating construction. I mean, finally, on the policy question, our fundamental position on that is it's a matter for the Cayman legislature as to whether contributory negligence should be available in the context of contract claims where there's concurrent liability and tort. That would have to be considered in the particular context of the Cayman Islands. In the English context, it's fair to say one tends to think about concurrent liability primarily in the fields of solicitor negligence, auditor negligence, and so on and so forth. The context in the Cayman Islands is not the same. It's obviously rather different with its very large investment fund industry. One might well not take the same view about the liability of custodians and administrators and other service providers to investment funds. One could quite take the view that if such a service provider has assumed duties to a fund under a service contract, including to exercise reasonable care, why should it mean that damages are reduced for the benefit of investors, possibly substantially, merely because there's a current duty of care in tort? And indeed, there is a legitimate viewpoint that it's not appropriate to apply contributory negligence to claims for breach of contract at all, including where there's contributory concurrent liability and tort. If parties contract for performance by the defendant of a particular duty, why does it matter that the defendant may also be liable in tort? And what should matter is what the parties have provided for in the terms of the contract, in terms of limiting or excluding liability. So we quite accept it's a point on which there are undoubtedly competing views, competing arguments, but those are the sort of points and arguments which would have to be balanced and evaluated by the legislature, no doubt following consultation. The exercise I may suggest your lordships have embarked on at the present time is an exercise in statutory construction.
Can I just ask you before you leave a point? Yes. The definition of fault in the Cayman law,
yes,
is in a relevant arm of it is an act which, prior to the operation of this law, would have given rise to the offence of contributory negligence. Now, there's obviously an issue about whether you can apply an always speaking construction to a temporally specific provision, but a simpler question is, prior to the operation of this law, does that mean prior to 1996?
Well,
or does it mean
if that language was introduced in 1977, so that was one of the changes they made in 1977 when they introduced the 1977 law. Prior to that, in the 1964 law, it had said, I think, apart from this law.
Yeah, that'd be like the UK provision.
Exactly, and then that was changed actually in 1977. So, I mean, if there was a relevant date for those purposes, I think it would be 1977. So, my lord, that deals with the first aspect of contributory negligence. The second aspect, you'll be pleased to know, I hope is going to be somewhat shorter. This assumes that we're wrong on the first aspect, which I've just been advancing, and that the Vester and Butcher classification is the correct way to construe the Cayman statute. And the issue that then arises is as to what category Primeo's claim against the second respondent falls into. As I said in opening, the judge said it was category 1, and therefore contributory negligence didn't apply. The Court of Appeal, however, said it was category 3. And we say that's wrong. It's not a category 3 case. It's either category 1, as the judge held, or alternatively category 2. Now, if I can just remind you of the categories, those are at 4106 of Vester. We looked at them earlier. They're in the second, the middle of the page, just below letter F. So one has the three categorizations, and essentially, long and short of it is contributory negligence will only be available to the contract claim where the liability in contract is the same as his liability in the tort of negligence independently of the existence of any contract. So you're looking for a case where the liability in contract is the same as the liability in the tort of negligence. Now, the relevant provision, contractual provision in our case is Clause 16B of the custodian agreement. And this is at page 439, at 449. So the custodian agreement is at 439. The relevant provision is at page 449. And it's clause 16B, which you see at the bottom of the page. It contains a number of different elements. The first sentence effectively gives the custodian a permission to appoint agents, sub-custodians and so on to perform its duties. The second sentence imposes a duty to use due care and diligence when appointing those sub-custodians. And then it's the third sentence that really matters for our purposes over on page 450. The custodian will require the sub-custodian to implement the most effective safeguards available under the laws and commercial practices of the sub-custodian's jurisdictions in order to ensure the most effective protection of the company's assets. Now, that's the contractual obligation which the judge found to have been breached in this case. On the facts, the judge held that this obligation required the second respondent to recommend to Primeo the relevant safeguards to be implemented. And that's his judgment at paragraph 193. And he said, quote, "In the circumstances, it's the failure to make the recommendation which constitutes the breach." So that's the obligation, and that's the way in which the judge held it had been breached. Now, as a starting point, we obviously make the point that the most effective safeguards duty, as I'll call it, is not expressed in terms of a duty to take reasonable care. It's a duty to do something specific, to require the sub-custodian to put in place the most effective safeguards in order to ensure the most effective protection of the assets. So a duty to do something specific in order to lead to a particular result, put in place the safeguards, ensure most effective protection. Now, as an opening comment, one might say, well, it's not obvious why that would give rise to the same liability as would exist in the tort of negligence, independently of the existence of this clause. And that was, in essence, the judge's view. He held, therefore, this was a Vesta Category 1 case. Now, the Court of Appeal took a different approach on this point. If we go to 365 of the electronic bundle, they deal with this at paragraph 491 onwards. They say in 491, ultimately the question turns on the construction of clause 16B. And then skipping to the third sentence, taking the parts of the clause 16B imposing a duty on R2 in isolation, Mr. Smith's points have considerable force, but to focus on the language of the contract in order to determine the nature of a person's liability in contract must reflect the clause and the contract as a whole. So they appear to accept that our points have force based on the terms of the contract delineating the duty, and importantly, they don't suggest that the clause contains an implied term to exercise reasonable care and skill, so far as the most effective safeguards duty is concerned. But what they then do in 492 onwards is reach a contrary conclusion based on the effect of the indemnity and exoneration provisions also included within clause 16 of the agreement. So what they basically say is, well, the duty itself isn't expressed in a way which is a negligence type duty, but when you add in the effect of the indemnity and exoneration provisions, the net result is that the second respondent is only liable where it's failed to take reasonable care. Now, in our submission, that approach is erroneous for three reasons. First, in contrast to the position in relation to the first respondent, as I say, this is not a case where it's said there was a contract with the second respondent to provide professional services, which was subject to an implied term to exercise reasonable care and skill, and where there was a concurrent duty of care in tort to exercise reasonable care and skill in relation to the provision of such services. So it's not, that was the case the respondents had run before the Court of Appeal. It was unsuccessful. They're not pursuing it further. So this wasn't the classic Vester and Butcher category 3 case where you've got a duty of care in tort to exercise reasonable care and skill in relation to the provision of services, and that there's an implied term in the contract to exercise reasonable care and skill in relation to the same services being provided, and one can therefore say there is concurrency. Now, as I said, the relevant duty on the second respondent under the custodian agreement was to do something specific, leading to a specific result. The breach of that duty is not a breach of a duty to exercise reasonable care and skill. It's a breach of a duty to take a particular step and to obtain a particular result. As the judge in our submission correctly observed, those are different duties. We can just go to 178, paragraph 317 of the judgment.
Would you give the page number?
Yes, it's 178 of the bundle. This is 317 of the judge's judgment. And it's the penultimate and final sentences of paragraph 317. He says, anti-penultimate and penultimate sentences. He says, clause 16b provides that the custodian will require the sub-custodian to implement the most effective safeguards available under the laws and practices of the applicable jurisdictions. I mean, he then actually omits the following bit in order to ensure the most effective protection of the assets. This is not the same as a duty to safeguard the assets in a manner to be respected of a reasonably competent global custodian. Now, in our submission, he must be right about that, because the clause 16.b duty isn't a duty that depends on the exercise of reasonable care and skill. It's a duty to do something by reference to a specific threshold in order to ensure a specific result. Now, so the first point, just focusing therefore on the nature of the duties, the duty we're concerned with in 16b is fundamentally different to the duty of care which might arise in tort, which would be, if at all, a duty to exercise reasonable care and skill in the provision of the services. The second point, we do submit that the nature of the most effective safeguards duty, as I'll call it, is not then transformed into a duty to take reasonable care and skill in relation to the provision of a service by reason of the existence of the indemnity and exoneration provisions, which was essentially the Court of Appeal's approach. In our submission, that's to confuse the nature of the duty and the question of breach of the duty with the issue of the ultimate liability for which the respondent may be called upon. The exoneration and indemnity provisions don't change the scope and nature of the duty. What they do is deal with the position once the duty's been breached. and limit the circumstances in which damages may be payable for breach of that duty. And indeed, the indemnity provision works in a different way still, because that simply provides for a contractual right to an indemnity. In theory, it gives rise to a defence of security in action, but it doesn't actually bear on the question of the duty. And in our submission, what those provisions don't do is change the nature or the scope of the original duty. What they don't do is convert a contractual duty to do something specific into a duty which is in effect concurrent with the duty to exercise reasonable care and skill in tort. So we do submit the Court of Appeal was wrong in regarding that as being the effect of the exoneration and indemnity provisions. I should say,
could you remind me of the paragraph where the Court of Appeal makes the finding that you speak of?
Yeah, so it's essentially 492 of the Court of Appeal's judgment through to 494, which I think should be back at 365. Yeah, so it's essentially, having in 491 said there's some force in the point I've just been making about the language of Clause 16b, they then go on in 492 to deal with the indemnity and the exoneration provisions. And then that point, if we go on to 366...
Well, when I read those paragraphs, I thought the Court of Appeal was distinguishing between the duty and its breach on the one hand and the nature of the liability that occurred on the other, harking back to what Mr. Justice Hobhouse says in Category 3, where he's comparing the liability rather than the duty. So I wonder if it's right to emphasise the duty and its breach, but rather look at the liability that occurs. What are the circumstances in which R2 can be found liable under this contractual provision?
Yes, I mean that's certainly the way the Court of Appeal analysed it. I mean, in our submission, that's not the correct way of looking at it. And where you're looking at the question of concurrency in contract and tort, you have to ask yourself, well, is the duty which the defendant is under concurrent with one which is existing in the law of tort? So
you were saying, as I understand it, that the Court of Appeal confused the nature of the duty and its breach with the issue of ultimate liability. I wonder if they did. I mean, it seems to me that they may have accepted that the duty was the duty for effective safeguards, but that the liability only occurred in certain circumstances which had to involve a lack of due care.
Well, I mean, if you get to 494, I mean, just looking at how they analysed it, as I understand, the nub of the reading is perhaps, I think, the final sentence of 494. Because as I understand it, what they do is they take the original language of 16b, but then say, well, because of the effect of the exoneration indemnity provisions, the duty ultimately, in reality, is the duty, is the word they use, a duty to exercise reasonable skill and care in connection with the most effective safeguards.
Yes, I see. You can rely on the final section of 494 to say that.
Yes.
That was what they've done, but what they seem to say above that is that they're drawing a distinction between the basic duty stated and the circumstances in which liability occurs.
Yes. I can see, if I may say that, why you say that, but I think fundamentally, there isn't a case we've been able to find which deals with this sort of particular question of where you have a contractual duty which is cast in different terms, but then you sort of superimpose on top of that indemnity and exoneration provisions and say, well, the net effect of that is to take you to the same position. Now, I mean, if we go back to Vesta, mean, your lordship's right that he's. I mean, if you look at category 3, I mean, he talks about liability in contract. Although it's clear from the preceding provisions, I think that he's talking about liability in the sense of that arising from the contractual provision. But in our submission, what he is fundamentally concerned with here is a situation where your duty, which gives rise to the liability, is the same in tort as it is in contract. I mean, you can see that, I think, from when he goes on, because he then says the dividing line between categories 2 or 3 may shift from time to time as the law's current perception of the scope of the purely tortious duty of care is reconsidered by the courts. I mean, when he uses the word liability, well, it seems to us he's using that as the concomitant of the duty, is he not? Rather than looking at what the sort of net effect might be in terms of the money you have to pay out once you build in all the other provisions of the contract.
Thank you.
So we do submit that they're wrong about that. But then thirdly, and perhaps most fundamentally of all, neither the respondents nor with respect to the Court of Appeal actually identify what the concurrent duty in tort would be in this case, or indeed what the foundation for it is. So, I mean, let's assume, for the sake of argument, that the Court of Appeal were right in the way they identified the contractual duty. That obviously only takes one so far, because ultimately the other part of the analysis is to identify the concurrent duty in tort. Now that, with respect to the Court of Appeal, is not something that they grapple with at all. They deal with the contractual side. They don't deal with the question of, well, what is the liability in tort? What is the basis for it? The respondents, in their written case, don't identify any authority at all, so far as we can see, for the imposition of a duty of care in tort on the second respondent, which would be concurrent, the same as the contractual duty which the Court of Appeal found. So that there isn't any case law on that point. They rely, and this is paragraph 66.2 of their case, on a passage from a textbook on global custody, which is at 10.233 of the electronic bundle. And I mean, I'll let your lordships read the passage for itself. This is a part of a textbook on the law of global custody. It's paragraph 6.61, so in the middle of the page on 10.233. So I mean, the textbook doesn't say there is in fact a duty of care in tort in these sort of terms. And there's no reason
Well, is 661 talking about the same thing as the contractual duty in 16B?
Well, this is, I mean, arguably not, because you can make the point that it's actually dealing with the choice of custodian. But this is what we understand it is relied on in the respondent's case. I mean, perhaps if we just look at their case, so I'm not misquoting him, it's 2373. Sorry, 2373, it's paragraph 66.2. And you'll see the proposition that they need to establish is that which is stated in the first sentence of 66.2. And in particular, they would need to establish the second part of that in particular, about ensuring the safekeeping, effective protection of the customer's assets under the local law and practices of the sub-custodian. Now, the text I've showed you doesn't support that at all.
Also, can I ask, I mean, is it a text about English or Cayman law? I mean, it seems to be at quite a high level of abstraction and makes reference to local laws rather than being a textbook statement. There is a duty of care that.
No, that's exactly right. I mean, it's essentially a financial text, I think, would be the way to describe it, about the operation of global custodians in the financial market. But I mean, I focus on this just because it's obviously critical to the argument of the respondents to be able to say that there is a duty of care in tort, in particular in relation to the implementation of most effective safeguards. Now, if we can just go back for a moment to the Court of Appeal judgment at 492. Yes, of course.
I think I understand paragraph 66.2 of the respondent's case. It's clear. A custodian has a tortious duty to exercise reasonable care and skill in ensuring the safekeeping or effective protection of the customer's assets. Right. I'm not sure I understand 661 of the textbook. What is the first? What is it?
If we go back to, sorry, I've lost it on my screen. If we go back to that 10233.
Yeah. The initial choice of the members of the network.
Yes.
And reviewing that choice from time to time. What's that actually
referring to? What that is concerned with is that where you have a global custodian, say someone like HSBC, it will probably appoint what are called a network of sub-custodians in particular jurisdictions who will own assets. So if you've got HSBC, say in London, it might appoint someone in Tokyo, someone in Hong Kong, someone in New York, and they form what's called a network of sub-custodians. So what it's saying there, I think, is that care should be taken in choosing who you appoint as part of that network.
Yeah.
And obviously that's right. But I mean, fundamentally, this doesn't support the proposition for which it's been cited. I mean, this is dealing with a rather different point about how a global custodian should go about appointing its network of sub-custodians.
And the criteria referred to in the second sentence are criteria for the selection of the members of the network.
Yes, exactly. Exactly. And you get that also from the final sentence, which you say you need to take into account the impact of insolvency law. Now,
it's not just the selection of members of the network in a particular jurisdiction. Presumably it is, do you wish to have a sub-custodian in a particular jurisdiction having regard to these features of the local law?
Exactly, yes, that as well.
So it's really guidance on good practice rather than a statement of legal duty.
Exactly right. So, I mean, it's fundamentally dealing with a rather different topic, and I think, if I may say so, your lordship's right to say it's a point of practice rather than a point of law. Now, I mean, I go to this because, as I say, fundamentally, the Court of Appeal's analysis depends on identifying a tortious duty, which is the same, tortious liability, which is the same as the liability in contract. Now, if we go back to 492 to 494 of the Court of Appeal's judgment, which we were looking at a moment ago, yes, and if we go over to 366. Yes, and just focusing on that language I pointed to a moment ago at the end of 494, what they identify the contractual duty or liability as being is to exercise reasonable skill and care in connection with the most effective safeguards. So that is their analysis of what the contractual duty is. Now, in order for this point to get off the ground, that gives you half of the answer. You then have to ask yourself, well, what's the basis for the duty of care in tort to exercise reasonable care and skill in relation with the most effective safeguards that one's required to put in place in relation to a sub-custodian in order to ensure the most effective protection of the assets? I mean, how does one get that from the law of tort? So in our submission, there isn't a basis for that sort of granular duty, which is concerned with something very specific about how one goes about dealing with a sub-custodian where you've appointed it. It is a creature of contract. They don't identify a concurrent duty of tort, concurrent duty in tort. So fundamentally, that's why we say, well, either the judge was right, and you say, well, actually, this is a Category 1 case because the duty is to do something specific. It's not cast in terms of a duty to take reasonable care. The exoneration indemnity provisions can't change the nature of that duty. That takes you to vest a Category 1. Or you say, well, the Court of Appeal's analysis of the contract was right, and you can, taking a step back, looking at it holistically, to say that it's in reality a duty to exercise reasonable skill and care in connection with the most effective safeguards. But then you don't have a basis for saying that there's a concurrent duty in exactly those terms as part of the law of tort. And no basis for such a duty has been identified by the Court of Appeal or in any case law or by the respondents other than that extract from the textbook, which I respectfully suggest doesn't really support the point. So, I mean, those are our submissions on why we say it's either Category 1 or Category 2 of VESTA. There is just one point just to pick up on. It's a point the respondents make at paragraph 66.1 of their case. If we go back to 2373. Final sentence of 66.1, they say that the learned judge made an express and unchallenged finding to the effect that the duty under the contract to implement most effective safeguards was to the standard of reasonableness, and they rely on the Grand Court judgment at 322. That is, in our submission, not fair to the judge. If you go to 322, at 180 of the bundle, and perhaps if we can just pick it up at 179, what he's doing in this part of his judgment, as you'll see from the bottom of 179, is attempting to provide a summary of his findings. And then if you go to 322 over the page, you'll see he deals in 322 with clause 16.b globally, and he in that context he says it's an implied term of the contract that in performing these duties, HSSL will exercise the care and skill to be expected of a reasonably competent global custodian. Now that is somewhat misleading shorthand because he's not dealing with the different elements of 16b. If you go back to 317, the part we were just looking at on page 177, it's quite clear from what he says at the end of that paragraph that he doesn't regard the most effective safeguards obligation as being, in effect, a duty to take reasonable care. In fact, he expressly says the opposite. So that sentence at the end of 322, although the respondents alight upon it to say, aha, the judge found that the most effective safeguards duty was a duty to exercise reasonable skill and care, that is not, in fact, an accurate summary of what he did find, which is in 317. And in fact, the Court of Appeal dealt with this particular point. If you go to 488, page 364 of the bundle, it's the penultimate sentence of 488. And they say the judge's language in other sections of the judgment, including the references in the paragraphs relied on by Mr. Gillis to the standard of the reasonable, competent global custodian, which C256 both he describes as the key issue on clause 16b, was loose in the sense of running the elements in the three duties together. So I just deal with that point. I don't think it ultimately assists with the analysis. So, those are our submissions on the second aspect, which is the correct categorisation of VESTA. As we indicated in the reply case, we're not pursuing the argument at paragraph 75 to 96 of our first written case based on Becker and Med and the subsequent authorities. Rather, in circumstances where the respondents are seeking on their cross-appeal to open the decision on the Court of Appeal on the amount of any contributory negligence reduction, then if the Privy Council was minded to revisit that issue, then we would contend that the relevant reduction is zero for the reasons explained by reference to the facts set out in those paragraphs of our case. Our primary position is on when we come to contributory negligence reduction is that the Court of Appeal has decided the point and the Privy Council shouldn't revisit it. But if we were wrong on that and the Privy Council did consider it appropriate to revisit the percentage reduction, we would rely on those points at that stage to say that, in fact, the reduction ought to be zero. So this is essentially going to the point I think my Lord Reid adverted to earlier, which is that the relevance of the contract might be relevant to the question of the degree of contributory negligence. So we would rely on these points if we get to the stage ever of the Privy Council being minded to revisit the question of percentage reduction. We don't advance them as part of our own appeal. So that completes contributory negligence. The next topic is the question of limitation. This splits down into three subtopics. The first is the legal test, which is a question of construction again, this time of Section 37.2 of the Cayman Limitation Act. Secondly, the question of whether the legal test is satisfied. And thirdly, the question of Primeo's own knowledge and whether that bars a claim in any event. So dealing with those in turn, the first is the legal test. And I say this is a question of construction as the interpretation of Section 37.2 of the Cayman Limitation Act, which is at 9486 of the bundle. Now, the particular issue is in relation to subsection 2. And specifically the phrase deliberate commission of a breach of duty. Now, in the courts below, as they still do, the respondents contend that encompasses only a knowing or intentional breach of duty. We've contended throughout that it also includes a breach of duty which is committed recklessly. And in that respect, our position is essentially the same as was reached subsequently by the English Court of Appeal in the Canada Square case, construing the equivalent provision of the English Limitation Act 1980. So this is a point which we advanced before the judge and indeed the Court of Appeal. The Court of Appeal were against us on it, as were the judge. Subsequent to the Cayman Court of Appeal, the English Court of Appeal has produced its analysis, which effectively supports our argument. Sorry, can we just go? And it's obviously relevant because we say breaches of duty in this case were committed recklessly, and therefore, if they're committed recklessly and that amounts to deliberate commission of a breach of duty, in circumstances where the breach is unlikely to be discovered for some time, then that amounts to deliberate concealment for the purposes of 37(1)(b). And that means, as your lordships will appreciate, the period of limitation doesn't then begin to run until the plaintiff has discovered, or could with reasonable diligence have discovered, in this case, the concealment. So it's a point which is of relevance to the time at which the limitation period begins to run. The effect is that if there is deliberate concealment, it means it won't begin to run until there's been discovery, or there could have, with reasonable diligence, have been discovery of the concealment. Now, if we just deal with the arguments, the respondents say that the meaning of the relevant words in section 37(2) is clear, and that they don't include recklessness. That is different to the view of the Court of Appeal in the Canada Square case, who thought that there was no clear natural meaning in this context. And that's paragraph 94 of the Court of Appeal at 3383. In our submission, the English Court of Appeal was right about this. The respondents' submissions ignore the fact that there are two elements to the wording in section 37(2). There's a conduct element. In other words, you need to intend to do the act, which is a breach of duty. But there's also a mental element, which is that you have to have the requisite state of mind as to whether the act is a breach of duty. So in other words, you must intend to do the act, but you must also have the necessary state of mind as to whether the act you're doing is or might be a breach of duty. Now, the word deliberate, seen in isolation, doesn't provide much guidance in relation to those two distinct elements. It doesn't answer the question whether it's sufficient that you intend to do an act, but you're reckless as to whether it is or isn't a breach of duty. We submit that would be sufficient for the purposes of amounting to a deliberate commission of breach. Now, that analysis in relation to the conduct element and the mental element can be seen from an earlier Court of Appeal decision in a case called Williams against Fanshawe, Porter and Hazelhurst, which was also a case dealing with the equivalent provision of the English Limitation Act, section 32. By way of background, this was a case of a negligent solicitor who had failed to tell his client that he had mistakenly agreed to a consent order dismissing the client's medical negligence claim. And the solicitor was somewhat embarrassed, perhaps understandably, about what had been done. And he failed to tell the client about the fact that the claim had been dismissed. And it was held that that was a case of deliberate concealment, falling within section 32(1)(b). Now, there were two judgments given by Mr. Justice Park, but also by Lord Justice Mance. And it's the Lord Justice Mance judgment I want to pick up just for the moment on this point. His judgment begins on page 9102. And he's dealing here with, as I say, deliberate concealment. In our submission, the analysis he applies to the word and the concept apply equally to deliberate commission. He says at paragraph 27, the wording of section 32(1)(b) refers to a situation in which any fact relevant to the plaintiff's cause of action has been deliberately concealed from him by the defendant. This wording is open to differing interpretations. We have to consider what the words deliberately concealed require by way of mental element and conduct. Now, we respectfully agree with that. That is our submission. There are the two elements to it. You need to look at both conduct and mental element. And as you say, the wording requires the defendant to know some act. The fact must be relevant to the cause of action. And then there's a question of the applicable state of mind as well, and also the question of the reason why it's not communicated by the defendant. If we go on to paragraph 31, 9103, he refers to the judgment of the House of Lords in a case we'll come to shortly as well, Cave against Robinson, Jarvis and Rolfe. He says Cave's case decided that the wording of section 32.2, deliberate commission of a breach of duty, requires the defendant not merely to have intended to do an act which constituted a breach of duty, but also to realise that the act involved a breach of duty. So you have the two elements. You have to do the act, but you also have to have the state of mind as to whether the act, the necessary state of mind as to whether the act actually involved a breach of duty or not. And then paragraph 36 on page 9105. He deals with his conclusion really in relation to deliberate concealment against letter B. He says, if a solicitor decides not to disclose any fact falling within either one or two to his client, so those are facts both known to the solicitor, knowing that it is his duty to do so, or what amounts in law to the same, being reckless as to whether or not it is his duty to do so, then he can in each case be described as having deliberately concealed the fact from his client. The deliberateness derives from his knowledge that he ought to disclose and his intentional disregard of his duty to do so. So the concept of deliberateness, this time in the context of deliberate concealment, means you have to have a conduct element, which is the non-disclosure of the fact, but then you also have to have the requisite state of mind, which is you have to either know it's your duty to disclose it or be reckless as to whether or not it's your duty to disclose it. And if you put those elements together, then that can properly be described as deliberate concealment. Now, we obviously rely very heavily on this, as did the Court of Appeal, not least the English Court of Appeal, not least because of the reference in parenthesis, knowing that it is his duty to do so, but then in parenthesis, or what amounts in law to the same, being reckless as to whether or not it is his duty to do so. So it's helpful both in terms of identifying the conduct element and the state of mind element, but also when one's looking at what is necessary for the state of mind element, he's quite clearly saying, well, recklessness is sufficient. Now, if we just complete that at paragraph 38, 9105, and this is the final bit of 9105, he makes a very similar point just above letter C. I consider that there could, even on the more limited reading, be deliberate concealment within the subsection in any case where the defendant deliberately concealed a fact, realising that it was relevant, or reckless as to whether or not it was relevant to an actual or potential claim against him, even though he might himself believe that any claim would, if pursued, prove to be ill-founded. Third, the relevance of recklessness and the irrelevance of motives in the present discussion follow as a matter of general principle, although both are reinforced by vigorous remarks by Lord Greenmaster of Rolfe in the case of Beeman against Arts, to which I've already referred, and we'll come to that. But it's clear from this case that Lord Justice Mance considered that in the context of 32.1b, there could be deliberate concealment where the party commits the relevant act by making the decision, by not, intending not to disclose the fact, but where he does so with a state of mind, either knowing that it's his duty to disclose, or simply being reckless as to whether or not it is his duty to disclose. Now,
but he doesn't suggest that recklessness would be enough for deliberate commission of the breach of duty.
well, he doesn't. He's not dealing with deliberate commission specifically, although certainly our submission is that where you're looking at section 37, 1 and 2, deliberate must bear the same meaning in subsection 2 as it does in 37, 1b, subsection 1.
Well, you took us to where he cites Cave, the case
Yes.
of Cave, as authority that deliberate commission requires knowledge that the act involves a breach of duty.
Well, I'm going to come to Cave's case in a moment. I mean, what Cave's case doesn't quite decide that. What Cave's case decides is that a merely negligent breach of duty isn't sufficient. I mean, the choice before the House of Lords in Cave's case was essentially between an intentional breach of duty and a negligent breach of duty. They didn't, in fact, consider the mid-ground of a reckless breach of duty at all.
I'm just looking at what Lord Justice
Yes, no, I
Nance,
mean, you're absolutely right. I mean, that's...
says about in paragraph 31.
Yes, but I mean, he absolutely, and I mean, that's why I showed you that. But he does make clear in relation to the actual wording he's analysing, which is deliberate concealment, that so far as deliberate concealment is concerned, a reckless state of mind is sufficient.
Yeah. And he returns to it at paragraph 34,
Yes.
Second sentence. Deliberate commission involves knowledge of wrongdoing.
Yes. Yes, well, the question, but then I suppose, I mean, the question is, though, I mean, the answer to that in my submission, though, is if you go to 36, the passage I was just looking at on 9105, just below letter B, and it's the part in parenthesis. I mean, he's clearly equating a reckless state of mind with knowledge, because he says deliberate concealment arises where there's a non-disclosure, knowing that it's your duty to make the disclosure, or what amounts in law to the same thing, being reckless as to whether or not it is his duty to do so.
Yeah. So for the purpose of deliberate concealment, he doesn't require actual knowledge of wrongdoing, whereas he accepts that it is required for the purpose of deliberate commission.
No, I mean, in my submission, no. I mean, I think what he says is, if you go back to the passage you were looking at,
yeah.
I mean, he refers to the need for knowledge of a breach of duty, and I think that was the first sentence of paragraph 34. Second sentence of paragraph 34,
yeah.
Which your Lordship referred me to. Deliberate commission of a breach of duty involves knowledge of wrongdoing. But he then makes clear, does he not, that when he's talking about knowledge, he regards recklessness as amounting to the same thing, which is what you get from paragraph 36 against letter B. So in my submission, what he's saying is the concept of knowledge of breach of duty encompasses being reckless as to whether or not what you're doing is a breach of duty.
I see.
So that's essentially the point. And we'll come to Cave in a moment, but as I say, Cave doesn't actually decide the recklessness point at all. It wasn't bearing on that. But the other point is, although you can say Lord Justice Mance was dealing with deliberate concealment in what was 32(1)b, it's very difficult to see how the word deliberate bears a different meaning in 32(1)b to the meaning it bears in 32 subsection 2. But what I primarily rely on primarily rely on the Williams case for really two purposes. One is the distinction it makes between what I've described as the conduct element and the state of mind element. In fact, you need to look at both. And secondly, so far as the state of mind element is concerned, the fact that he regards recklessness as amounting to knowledge or being treated as knowledge, in law it's the same thing. Now, if you translate the approach that was adopted there to section 32.2, it follows, we submit, that there can be deliberate commission of a breach of duty where a party intends to do an act which is in fact a breach and knows or is reckless as to whether or not it is a breach of duty. But certainly we disagree with the submission that the word deliberate carries with it a clear and natural meaning of the words, which excludes the state of mind of recklessness. Now, just looking at the matter in terms of the case law then, it's probably helpful to approach matters chronologically. The Limitation Act 1980 was, I think as your lordships have observed in another case, a consolidation statute. So it is permissible to consider the meaning and effect of the earlier legislation which replaced it. On the point we're presently concerned with, there are three relevant pre-1980 authorities which related to the predecessor provision, which was section 26B of the Limitation Act 1939. They're the Beeman against Arts case, Kitchen against the Royal Air Force Association, and King against Victor Parsons. We've set out the relevant passages in our written case. The Court of Appeal, the English Court of Appeal, also dealt with them in detail in Canada Square. If we could just go to 3390, which is paragraph 113 of the Court of Appeal's judgment. There's a section of the judgment beginning at paragraph 113, which goes through to 124, where they deal with these cases. And they observe at the start of 124 on page 3394 that these cases do establish that recklessness was a sufficient mental element under the old section 26. And that's consistent with what Lord Justice Mance said in Williams at paragraph 38. I showed you paragraph 38, he referred to what he called the vigorous remarks of Lord Green in Beeman against Arts. And I'm going to come to Beeman against Arts in a moment to look at that specifically. It's also consistent with what the Law Reform Committee concluded in their report that preceded the 1980 Act. And if we go to 10007, so 10,007, it's paragraph 2.23, where they refer to one of the three cases, which I've referred to, which was Lord Denning, and observe the title and the wording of section 26 are misleading in that it's not limited to fraud in the common law sense to embraces recklessness. It's not limited to case of active concealment. So, in relation to the position prior to the 1980 Act, essentially the position in relation to section 26B of the 1939 Act was that a reckless state of mind was a sufficient mental element. Now, if I can just show you, I'm not going to go through each of the three cases because they largely are to the same effect. I was just going to go to Beeman against Arts, which is at 3146, which is the Lord Green Master of the Rolls case, which was referenced by Lord Justice Mance in Williams. This was a case where packages had been deposited with the defendant for safe custody at the start of prior to the Second World War. The manager of the business then wanted to wind down the business, and he essentially disposed of the packages on the basis that it was said that they were of no value. The plaintiff found out sometime later, but that was more than 6 years after the packages had been disposed of. Now, the trial judge, who was Mr. Justice Denning at that point, had found that the relevant individual was honest, but the Court of Appeal had held that he had acted recklessly in disposing of the goods without making a proper attempt to ascertain their true value, and that was sufficient to engage the section. And you can see that vividly from 3161, page 565 of the report. In the second half of the page, he begins, I may sum up what in my view happened as follows.
Sorry, page again, please.
It's 3161, page 565 of the report. I may sum up what, in my view, happened as follows. The defendant's principal purpose, if not their sole real purpose, in getting rid of the plaintiff's goods was to obtain for themselves the commercial advantage of being able to close down their business. In breach of their duty as bailees to communicate with the plaintiff before converting her goods, they recklessly, and without making the slightest effort to ascertain the true position, assumed that communication was impossible. And it's noticeable, even after the Mediterranean was opened in 1943 on the surrender of Italy, they made no attempt to let the plaintiff know what they'd done. They recklessly, and without taking the least trouble to verify the facts, assumed that the plaintiff had not troubled about her goods and that large storage charges had mounted up and would continue to mount up, which the plaintiff would be able to pay. They recklessly formed the opinion that the goods were valueless without having any independent valuation, and disregard of the fact that the absence of pecuniary value could afford no justification for disregarding their obligations. So this was all a case actually involving a commission of a breach, an act, in other words, disposing of the goods, breaching their duty as bailees. And what was sufficient to engage the provision of the Limitation Act was that all of that had been done recklessly. Now, the position, therefore, by the time of the enactment of the 1980 Limitation Act was that, in our submission, recklessness was sufficient to engage the relevant provision of the 1939 Act. And then, so far as the 1980 Act is concerned, it's clear from the parliamentary materials that Section 32 was not intended to affect a substantive change from the existing law, but was in fact intended to update Section 26B into more modern language. Now, we deal with this firstly in our case at 2281. If we could just bring that up. It begins at paragraph 23. And there's a rather pithy statement from Sir Robert McGarry in Tito against Waddell, which summarises the position the law had got itself into prior to the 1980 Act. And the issue was that although Section 26 talked of fraudulent concealment, that was the heading of the section, as he pointed out, as the authorities stand, it can be said in the ordinary use of language, not only does fraud not mean fraud, but concealed does not mean concealed, since any unconscionable failure to reveal is enough. And then that led to the Law Reform Committee report, which we refer to in paragraph 124. And then if we go over the page, we've set out the statements that were made by the Lord Chancellor and the Solicitor General at the time the relevant legislation was passed. And it appears that the intention was effectively to update the language into a more modern form. The purpose of the clause is to restate the law more or less as it is, in language which is more or less contemporary. And then effectively that's the consistent message one gets from the other passages as well. The Court of Appeal in Canada Square also dealt with this at paragraphs 125 to 135 at 3394. And this is, there's a passage beginning at 125 and it goes all the way through to 135. And if we go to 135, they ultimately refer to what was said what is said in Clark and Linsell. But what that material shows is essentially the legislative process wasn't intended to change the law. What they thought they were doing was effectively dealing with the language issue that had arisen because the language of fraudulent concealment wasn't apt, and that was being updated into what was regarded as being a more modern formulation.
But I mean, wasn't the Limitation Act 1980 Consolidation Act?
Yes, indeed. Yes.
So why isn't the standard Farrell and Alexander approach to interpretation applicable? In other words, you start with the language of the Act itself. It's only if there's ambiguity about the language of the Act that you go back to the earlier materials.
Yes. Well, I don't think we dispute that as the applicable principle of construction, but the question then is, well, what does deliberate commission mean? Which is why I said at the start, well, at the very least, there is ambiguity in what that means. The respondents, for their part, say the words deliberate commission is crystal clear. It can't mean recklessness. In my submission, that's not right, and at the very lowest, there is ambiguity because you need to look at the conduct element, you need to look at the mental element. There's a question of intending to do the act, which is the conduct element, and then the question of the state of mind you need for the mental element. And so far as the mental element is concerned, the question of a deliberate commission of a breach is capable, I would submit, of including a breach which is done intentionally, but with a state of mind which is reckless as to whether or not the act is a breach. Yes. But I don't think we certainly don't take issue with Farrell and Alexander, and indeed how that was referred to in the FII test claimants case. But we submit that this is a case where it is both permissible and necessary to look at the meaning of the anterior legislation. So one's then in a position where you've got the pre-existing 1980 position. One's then got the parliamentary material, which suggests there wasn't an intention to change the law. So far as the post-1980 authorities are concerned, there's a decision in Cave against Robinson, Jarvis and Rolfe, which we touched on a moment ago, and which was relied on heavily in the judgment of the Court of Appeal, Cayman Court of Appeal. That's at page 3457. Now, in our submission, the critical point about Cave and Robinson, Cave against Robinson, Jarvis and Rolfe, it doesn't say that recklessness is not sufficient for the purposes of 32.1b or 32.2. It was concerned with the different question of whether or not a negligent breach is sufficient for the purposes of section 32.2, and it held that it was not. And it, with the point which the House of Lords were concerned with is really very concisely put by Lord Millett in paragraph 17 on page 3465. And he said that the question is whether the words deliberate commission of a breach of duty in section 32.2 of the 1980 Act mean deliberate commission of an act or omission, being an act or omission which gives rise to breach of duty, or simply mean deliberate breach of duty. If the latter, then they refer only to a breach of duty which has been committed intentionally. The distinction is between an intentional wrongdoing on the one hand and negligence or inadvertent wrongdoing on the other. So the issue he was grappling with was essentially a binary choice as he saw it, and that was how it arose on the facts of that case. Is negligence sufficient, or does it have to be intentional? What he wasn't doing anywhere was grappling with what might be said to be the mid-ground between those two poles, which is the question of an intentional act which is committed recklessly as to whether or not it's a breach. And indeed, the point didn't arise on the facts of Cave, because no one was saying that the solicitor's breach of duty had been done recklessly. It was a breach of duty which had been done negligently. So the fundamental point about Cave is that it doesn't address the question whether an intentional act done recklessly as to whether or not it was a breach is sufficient. And in our submission, the English Court of Appeal in Canada Square was exactly right to say that Cave does not decide that recklessness is sufficient for the purposes of deliberate concealment, because it was addressing a different question. And if I can just show you where the Court of Appeal said that in Canada Square, it's 3388. They actually make this point in a number of places because they spend some time dealing with Cave, as you might imagine. But in paragraph 105, they make the point specifically by reference to the Court of Appeal in our case. And they say it wouldn't be right, in my judgment, to play too much weight on the analysis of the court in Primeo. So that's the Court of Appeal in our case. I do not agree that Cave decides that recklessness is not sufficient for deliberate concealment. It was addressing a different question. The Cayman court did not cite the many places at which Mance LJ expressly referred to recklessness being sufficient in Williams, as I've pointed out. And in our submission, the English Court of Appeal was exactly right in what they said about Cave. It doesn't actually decide the recklessness point. It was concerned with a different question, namely whether a negligent breach is sufficient. Now, the other case, post-1980, which is relevant, is Williams against Fanshawe, Porter and Hazelhurst, which I've already spent some time looking at. In our submission, the comments of Lord Justice Mance are strongly supportive of the view that recklessness is sufficient. Now, I accept he was dealing with the concept of deliberate concealment. But as I submitted, it would be very strange if the concept of what is deliberate is different for the purposes of deliberate concealment in 32(1)(b when compared with deliberate commission in 32(2). And he makes the point expressly in two places that a reckless state of mind is sufficient for the purposes of knowledge and therefore for the purposes of supplying necessary mental element needed for deliberate concealment. And I haven't got the reference to hand, but we will find it. I believe it was common ground between the parties in Canada Square in the English Court of Appeal that deliberate must bear the same meaning in 32(2) as it does in 32(1)(b). We'll see if we can provide the reference for that. Now, so those are the principal decisions. We then get to the position that where the base on which the Cayman Court of Appeal decided it, and you see that in 464 of the Cayman Court of Appeal's judgment, which is at page 355. And the essential foundation of their reasoning you see in the first sentence of 464. And where they essentially part company with the English Court of Appeal and indeed with our submissions is that they approach the matter on the basis that Cave versus Robinson did decide the recklessness point. We consider that Cave against Robinson does decide that recklessness does not suffice for purposes of section 32(2) and therefore for section 37(2). And in our submission, that is wrong because that was not the question before the House of Lords in Cave. They weren't faced with a reckless breach of duty. They didn't have to address the question of whether recklessness is sufficient or not. Now, so far as our position on this appeal is concerned, we obviously rely on the judgment of the English Court of Appeal in Canada Square. The reasoning and results in that case before the Court of Appeal are essentially on all fours with our submissions in the present case. Now, I should say this isn't obviously a position we've adopted in light of the decision of the English Court of Appeal. Our position on this issue was consistent and predates that. It was the position we've advanced before the judge and then before the before the Court of Appeal. In fact, the English Court of Appeal decision is subsequent to the Cayman Court of Appeal. As it happens, it's effectively to the same effect as the arguments we'd been advancing before the Cayman Court of Appeal. And essentially all the points which the English Court of Appeal makes in our submission correctly are points why it's correct to construe deliberate commission as extending to a breach which is done recklessly. What does that say? Yes, and so just to supply the reference to the point I mentioned a moment ago, it's actually paragraph 55 of Canada Square at page 3371. Paragraph 55, the parties are agreed on two things. First, that the existence and size of the commission is a fact relevant to Mrs. Potter's right of action for the purposes of 32(1)(b. And secondly, that the word deliberate connotes the same mental element for the purposes of section 32(1)(b as it does for section 32(2). And in our submission, that must be right. It's very difficult to see how deliberate could have a different meaning one subsection of the same section as compared with the other subsection. Now, as a matter of policy, we respectfully submit that it also makes sense for deliberate commission to extend to a breach which is breach of duty which is done with a state of mind of recklessness as to whether or not it is a breach. The goal is of the limitation provisions, of these limitation provisions, is to strike a balance between the objective of preventing the litigation of stale claims, whilst at the same time allowing a plaintiff a reasonable opportunity to bring a claim. And that's a point that was made by the House of Lords in the Cave case. It was a point which your lordships made in the FII test claimants case. We supply the references in our written case at paragraphs 144 to 145. It is a reasonable balance for Section 32 to be applied where a breach is committed recklessly as to whether or not the act is a breach of duty, as well as done in the knowledge that it actually is a breach of duty. Both scenarios involve a degree of culpable wrongdoing on the part of the defendant. In the one scenario, you actually know that what you're doing is a breach. In the other scenario, you effectively think it might be but don't care. Both of those are culpable states of mind on the part of the defendant. And if one's looking for a point at which one draws the line as to the type of conduct which does trigger the delaying of the limitation provision, it's appropriate for recklessness to fall on the intentional side of the line. Looked at it the other way round, I mean, there's obviously a fundamental difference between recklessness and negligence, because a negligent breach of duty can be committed, as your lordship knows, purely innocently. You may have no conception at all that what you're doing is wrongful or a breach in any way. There's a fundamental difference between that and, on the other side of the line, recklessness and intentional conduct. So in our submission, where a defendant is reckless, including a case where he simply doesn't care what he's doing is a breach or not, then it's appropriate to penalise him for failing to disclose it. So, my lords, in our submission on the first point, the question of the legal test, we submit the Cayman Court of Appeal was wrong. The English Court of Appeal is right. The correct legal test for deliberate commission of a breach of duty in section 32.2, 37.2 of the Cayman statute does include a breach which is done with a state of mind which is reckless as to whether or not what one is doing is a breach. Now, if we're right on that, we then move to the second subtopic of limitation, which is the question of whether the respondents were reckless. Now, since he held wrongly in our submission that the test for deliberate commission under section 37.2 did not extend to recklessness, the judge did not address in his judgment the question of whether the respondents were in fact reckless for these purposes. He approached it on the basis that recklessness wasn't sufficient for these purposes, and he didn't make, therefore, express findings as to whether or not the respondents were reckless for the purposes of section 37.2. The test for recklessness which we submit is relevant for these purposes is that set out by the House of Lords in R against G, and which was applied by the English Court of Appeal in Canada Square. Now, you'll see that at page 3381 of the bundle, paragraph 87. And I'm sure your lordships are familiar with R against G, which was essentially the resetting of the test for recklessness in light of the earlier decisions in R against Cunningham and R against Caldwell. And you can see from the penultimate and final sentences of that paragraph, the Court of Appeal said, having reviewed the earlier case law, Lord Bingham, with whom the other members of the Judicial Committee agreed, held that the correct test was that a person acts recklessly with respect to a circumstance when he is aware of a risk that it exists or will exist, and it is in the circumstances unknown to him unreasonable to take the risk. A person acts recklessly with respect to a result when he's aware of the risk that it will occur, and it is in the circumstances known to him unreasonable to take that risk. So if applied to a contractual duty and the question of whether your conduct might be a breach of duty, then the question is whether the person was aware of the risk that he would be in breach by his act or omission, and whether in light of what he knew at the time, it was unreasonable to take the risk. So there's both an objective and a subjective element. You have to know subjectively that what you're doing might be a breach, but also objectively it has to be unreasonable to take the risk. Now, so far as the objective element is concerned, the judge didn't address the objective element for the reasons I've already explained, because he didn't think we were right on the test under section 37.2. However, in our submission, the same material which led to the conclusion that the first respondent had been grossly negligent would necessarily lead to the conclusion that it was objectively unreasonable for the respondents to take the risk. Now, the judge dealt with this point in paragraph 2 to 8 of his judgment at page 127. But the question of gross negligence essentially arose from an episode which has been referred to by way of shorthand called the custody confirmations. Now, by way of very shorthand, just to explain what happened on the facts here, Primeo had its own auditors, who were Ernst & Young, who audited Primeo's financial statements. Prior to 2005, they had relied on work which was done by Bill Mrs. auditors. So Bill Mrs. Madoff, Bernard L. Madoff Investment Securities. For the purposes of preparing Primeo's financial statements, they'd effectively relied on work supposedly done by Bill Mrs. auditors, confirming that the assets existed at Bill Miss, and they then took that as the audit evidence, which was then used for the purposes of preparing Primeo's own financial statements, which they then signed off as auditors. Now, what happened in 2005 was that they, Ernst & Young, came to the conclusion that they weren't prepared to do that any longer. And there's reference in the materials to the concerns which were had at the time about whether the assets actually existed and so on and so forth. But for whatever reason, they said, well, we're not prepared to rely on Madoff's auditors any longer. Now, the question was, well, how does that mean that Ernst & Young are going to be in a position to provide an audit opinion on Primeo's financial statements? What actually happened was that the second respondent simply issued something that was called a custody confirmation, effectively confirming that the assets were held in custody, and that piece of material was then relied on by Ernst & Young as the audit evidence, entitling them to then provide an audit opinion on the accounts. Now, the gross negligence was that that custody confirmation was issued by the second respondent, obviously without having undertaken any check themselves that the assets actually existed. And you'll see that is really reflected in the judge's conclusions in paragraph 2 to 8. He says, continuing in this way, knowing that Ernst & Young was unwilling to rely on F&H, who were Bilmis's auditors, Freeling and Horowitz, and knowing that HSSL, the second respondent, had taken no steps to perform its duties under clause 16b of the 1996 custodian agreement, constituted a serious disregard of the risks associated with relying solely upon information supplied by Bilmis. So it's in some ways, although this is a case of complexity and lots of issues, I mean, the fundamental point is essentially a straightforward one, which is that the respondents issued the custody confirmation. They hadn't done any checks. They knew that the second respondent had taken no steps to perform its duties under clause 16b, and that custody confirmation was then relied on for the purposes of financial statements. As we know, as we found out sometime later, of course, the custody confirmation was false in the sense that the assets, of course, didn't in fact exist. And you'll see in 229, he then says that HSSL, the second respondent, continued to issue custody confirmations in respect of the subsequent audits. Now, as I say, he's obviously dealing with this in the context of gross negligence, because he doesn't deal with the recklessness point in terms. But in our submission, if one's asking oneself the objective question, is it unreasonable to take the risk? Well, in our submission, on the basis of those findings, it quite plainly is. Now, that then leaves the question of the subjective element, because it's obviously not the case where you're dealing with recklessness that the objective element is enough. There's also the subjective element. Now, the judge did address the state of mind of the relevant individuals for other purposes, not for the purpose of section 37.2. He wasn't dealing with that. He did address their state of mind for other purposes, and he deals with the question of state of mind in two principal places in the judgment. The first is paragraph 226. On page 126, and he focuses on the relevant individual, Mr. Fielding. And he says, in February 2005, Ernst & Young wrote to HSSL, the second respondent, expressing various concerns about Bilmis. In particular, Ernst & Young questioned whether it could continue to rely upon the audit work performed by Freeling and Horowitz, suggested it would need to perform the work itself, failing which it might resign. The resignation of Ernst & Young would have had potentially serious adverse consequences for Primeo in the event this result was avoided, because HSL agreed to provide a custody confirmation to Ernst & Young in respect to the assets held by Bilmis as sub-custodian, thus avoiding the need for Ernst & Young either to engage Freeling and Horowitz or do the work itself. From the perspective of BOB Cayman as administrator, so this time the first respondent, this decision has serious consequences which were ignored by Mr. Fielding. So finding is he essentially ignored the serious consequences. Mr. Fielding's view was that BOB was entitled to rely upon the auditors to do the work necessary to verify the existence of the assets. Whether or not his view was misguided, it became wholly untenable once he agreed to provide Ernst & Young with a custody confirmation. The evidence points to the conclusion that without this confirmation, Ernst & Young would have insisted upon auditing the balances on the Bilmis statements, failing in which it might have issued a qualified opinion or resigned. Having provided the key piece of audit evidence, HSSL, second respondent, gave up whatever justification it might have had for continuing to prepare NAVs based upon a single source of information. It became impossible for BOB Cayman to rely upon Ernst & Young's unqualified audit opinion. And then 228, he then addresses again the state of mind of Mr. Fielding. First sentence, Mr. Fielding is the ultimate decision maker. The manner in which Mr. Fielding dealt with the matter was not merely negligent. By his own admission, he failed to apply his mind to the issue. He was indifferent to the obvious risk of continuing to prepare an issue NAVs without the comfort of an unqualified audit opinion based upon supposedly independent audit work. Continuing in this way, knowing that Ernst & Young was unwilling to rely upon Fielding and Hoffitz's work, knowing that HSL had taken no steps to perform its duties under Clause 16b, constituted a serious disregard of the risks. Now, in our submission, that is recklessness. Yes, we're going on. That's my next one. Yes, thank you. Now, what he then goes on to say over the page is that it's not willful default because Mr. Fielding was not conscious that what he was doing constituted a breach of duty. But of course, what he doesn't deal with there is whether Mr. Fielding was reckless as to whether or not it was a breach of duty. And the reason he doesn't deal with the recklessness point, as I say, I mean, obviously he didn't have to, but if you go back to what he said in 228, indifference to the obvious risk, knowing that Ernst & Young was unwilling to rely on the work, knowing that HSSL had taken no steps to perform its duties, constituted a serious disregard of the risks. So he knows that they haven't performed their duties, and that is a serious disregard of the risk. I mean, in our submission, it's very difficult to see how that isn't recklessness in the subjective sense applying the RVG test.
But you are asking us to apply findings of fact addressed to the question of gross negligence to a separate question,
yes,
which is recklessness as to breach of duty.
Yes, I mean, I have to accept that because that's evidently right. Because, as I explained, the judge didn't deal with
didn't address it
quite. So, I mean, ultimately, that's why I think, as we explained in that written case, we have there's two ultimate positions as to our bottom line on this. I mean, either one says there is sufficient in the judgment on the basis of what he did find in a different context that one can conclude that is recklessness, or if one is driven to the conclusion, well, actually, he just didn't deal with the point sufficiently. Well, it would have to go back to decide specifically the recklessness point.
May I ask, what was your pleaded case on this? Because presumably the way the pleadings worked would have been that the respondents would have pleaded limitation.
Yes.
So you would have pleaded some exception to limitation.
Yes. We'll check that. I don't know the answer off the top of my head. It must have been dealt with in our reply.
Right.
We'll check that. I mean, there hasn't been a pleading point taken that recklessness. It's not open to us to advance the reckless argument, and it was very much part of the argument put to the judge, because of course he decided against us on the legal point. So it's not a new point. I mean, it's just that the way he dealt with it was just to decide against us on the legal issue, and he didn't then go on, as it were, to make findings on the contingency he was wrong on the legal issue. Now, just to deal with one point, the respondents suggest that the judge found that the respondents were not reckless because of his findings in relation to willful default. And so their submission is the judge expressly found that they weren't reckless. Now, in our submission, that's wrong. The test for willful default, which the judge applied, was set out at 209 of the judgment, which is page 118 of the bundle. And there is a curiosity in this part of the judgment. as you can see from 209, the well-known test for willful default has two limbs to it, derived from the City Equitable Fire Insurance case. Limb A is a consciousness limb. You have to be conscious that the act you're doing is a breach of duty. But then there's also limb B, which is the recklessness limb. So there's the two limbs to willful default. Now, what is curious about the judgment is when you come to 228 at 127, and the final sentence, which my learned friend referred to a moment ago, when he deals with willful default, he only deals with it by reference to the first limb. He doesn't actually deal with willful default by reference to the recklessness limb. He simply says it's not willful default because Mr. Fielding was not conscious that what he was doing constituted a breach of duty. But what he doesn't do, for whatever reason, and it must be an error on his part, is he doesn't deal with limb B, which is the recklessness limb. The language of conscious that what he was doing is a breach of duty is the limb A, and he doesn't anywhere deal with limb B, which is the recklessness limb. And there's exactly the same point if you go on to 174 of the bundle, paragraph 310. It's the final sentence of 310, which essentially makes the same point that we'd just seen in the final sentence of 228. Nor is there evidence from which to infer that the person actually responsible for issuing the NAVs, namely Mr. Fiorino, was conscious of what he was doing constitutes a breach of duty. Sorry, in fact, you probably need to just pick it up a couple of sentences prior to that. BOB Cayman was grossly negligent in the way in which it performed the NAV calculations in and after April 2005. Mr. Fielding's conduct did not amount to willful default. He was not conscious of the fact that issuing a custody confirmation would undermine the only justification for performing the NAVs on the basis of single source information. So again, for whatever reason, he only deals with willful default by reference to limb A, the consciousness test. He doesn't deal with it by reference to the recklessness test.
Did anyone go back to the judge and ask him to clarify this and make a finding in relation to this particular point?
We did. I mean, we can go. I'll perhaps provide you with some detail on it. When the draft judgment was provided, there was actually quite a lot missing from it in terms of issues that hadn't been dealt with by the judge, including, for example, I think the entirety of the strict liability claim. I think we certainly went back to him and identified various parts that did require further findings, including the strict liability claim, and then there was a further version of the judgment produced. What I don't know off the top of my head is whether, when we went back to him, this particular point was identified. I mean, I rather suspect it wasn't, although a large number of points, in fact, were.
If this point were to be remitted or to be decided at a further hearing, what would it involve?
Well, we'd have to have evidence, I think, from probably the same individual, Mr. Fielding, who gave evidence the first time round. So he was cross-examined by reference to the documents. So primarily it would be a question of cross-examining him again, I think, by reference to this particular issue. I mean, he was cross-examined, I think, for a number of days, but at that time there were a large number of issues in the case to which his evidence was relevant. On this particular issue, I suspect it's a rather narrow point of cross-examination because it ultimately comes down to the circumstances in which the custody confirmation was issued and what his state of mind was in issuing the custody confirmation ultimately.
Would it be possible to have a fair trial of that issue at this stage?
Yes. And there's no reason no reason why not in my submission.
Why is it not possible, assuming we agreed with you that a finding on this was required, why isn't it in practice possible for a finding to be made on the evidence that was actually led at this 40-day trial?
Well, that would be possible. I mean, yes. I mean, certainly. You mean does your lordship mean without reference to live evidence of a witness?
Well, I mean, without the necessity of further evidence.
Yes. Well, I think it wouldn't necessarily require further evidence. It's just, the question is just what material would the Grand Court judge need in order to make a finding on this? I mean, he could certainly make the finding based on the existing evidence. And we have the transcript, we have the witness statements, we have the documents. All of that is readily available.
Could I ask, why is the inference not, since the judge set out the test at paragraph 209 for willful default and makes a specific finding at the end of paragraph 310 that Mr. Fielding's conduct did not amount to willful default, why should the inference not be that the judge has considered both limbs of it and has positively found that neither limb was made out?
Well, because he only mentions in those parts of the judgment where he makes the factual findings the higher conscious that what you're doing is a breach of duty limb. I mean, it's very curious not to deal with what would probably be the lower bar when you're making the factual findings on this point. I mean, it seems...
And I wanted to ask you about paragraph 228 as well, because the judge refers back to evidence that he set out of Mr. Fielding at paragraph 110.
Yes.
And is it right to read paragraph 228 and indeed 110 as the judge essentially accepting that statement of evidence from Mr. Fielding?
In, paragraph 110?
110, yes, page 63. So I was rather reading paragraph 228 as the judge treating the relevant evidence of Mr. Fielding's state of mind as being what he himself had said in paragraph 110. As quoted in paragraph 110. Then I wonder whether it might be said that actually looking at that evidence, that wouldn't be enough to show reckless default on the part of Mr. Fielding.
Well, in my submission, I would expect to suggest 110 points in the other direction, doesn't it? Because what the judge is doing in 110 is effectively dealing with Mr. Fielding's evidence that where he said, and this is the sentence following the quote, broadly he didn't think they were under any safekeeping or supervisory obligations. And that's how the judge summarises the position as being put by Mr. Fielding. And then as I read the rest of 110, well, he's saying that can't be right. Mr. Fielding must have known that they were under custodial responsibility and they were under custodial obligations.
But the gist of the evidence of Mr. Fielding seems to be not, I appreciated that this was something that was a major risk and I decided not to do anything about it, but I just didn't think about it at all.
Well, I mean, Mr. Fielding's evidence, as the judge really summarises in 110, was that he was asserting that he didn't think. This was his evidence. He said at the time he didn't think the second respondent had a custodial responsibility in relation to the Bill-Myth assets. So he was effectively saying, well, I didn't think we were custodian. That was the case that was being advanced. Now, that case was the subject of a lot of attack and scrutiny at trial, and the conclusion was, in effect, the judge's conclusion in 110, well, that actually Mr. Fielding must have known that they were under custodial obligations. I mean, there was a raft of evidence to support that. And what he's saying Well, I respectfully suggested in 110 what he's saying is he's not accepting Mr. Fielding's evidence that he didn't think they were under any custodial obligation or responsibility. Mr. Fielding must have understood.
Of paragraph 114, the last two sentences. Yes.
Yes, indeed. Well, exactly. Yes, I mean that's exactly the point. Yeah, exactly.
Yes, thank you.
So, I mean, those are our submissions on the recklessness point. And as I say, we have effectively two submissions on it. Ultimately, either one accepts our primary submission, which is that the material does allow one to conclude there was recklessness in the RVG sense, or if we're wrong about that, and one can't do that from the judgment, one would have to remit it back to the Grand Court for that specific issue to be the subject of further findings. Now, that then takes me to the third topic, subtopic on limitation, which is the question of Primeo's knowledge of the breaches. Because finally, in relation to limitation, the respondents say that Primeo's appeal on the meaning of deliberate commission in section 37.2 is immaterial. And that's because they say of the judge's findings that Primeo was aware of the necessary facts to plead its claim at the time. Now, that's not the basis on which the section 37.2 point was actually decided against Primeo by the courts below, but we obviously accept that under section 37.2, time begins to run from the moment the claimant discovered the concealment or with reasonable diligence could have done so. So that is plainly an element of the 37.2 test. Therefore, it's necessary to address the point. Now, starting with the language of section 37, if we could just go back to that 9486.
Sorry, page?
9486. So it's the language that follows C. The period of limitation does not begin to run until the plaintiff has discovered or could with reasonable diligence have discovered the fraud, concealment or mistake. So what has to be discovered or with reasonable diligence could have been discovered is the concealment. Now, so far as 37.1b is concerned, that refers to any fact relevant to the plaintiff's right of action. Right of action is defined in section 2, subsection 7. It includes cause of action, so it's defined in an inclusive way, as including, amongst other things, a cause of action. And then 37.2 refers to concealment of the facts involved in that breach of duty. So 37.2 essentially deems that for the purposes of 37.1b, where there's been deliberate commission of a breach in circumstance in which it's unlikely to be discovered for some time, that amounts to deliberate concealment of the facts involved in that breach of duty. Now, it seems to us ultimately the question, therefore, turns on the construction of the phrase of the facts involved in that breach of duty. Because that, for the purposes of section 37.2, that is what is deemed to be concealed. And therefore the question is, when were the facts involved in that breach of duty discovered, or when, with reasonable diligence, could they have been discovered? Now, we suggest that can be read as a phrase narrowly, as including only the facts which constitute the breach. So in other words, it's the fact that is the breach. Or you can read it as meaning the facts which relate to the consequences of the breach and of which it's necessary to be aware in order to assess whether the plaintiff has a worthwhile claim. Now, we submit, as a matter of construction, the latter interpretation is the correct one. Now, the first point, just looking at the time, I didn't know
Yes.
that might be a convenient moment, given I was about to embark on a few submissions.
Rather than embarking on that just now, we could look forward to that tomorrow morning.
Thank you very much.
Very well, we'll adjourn and resume at 10:30 tomorrow.